Thank you. Thank you, Chairman Roskin, Ranking Member Levin, and members of the subcommittee. Thank you for the opportunity to testify this afternoon. My name is Claire Sylvia, and I'm a partner in the law firm of Phillips Cohen, which represents whistleblowers in False Claims Act cases. The False Claims Act is one of the primary ways that the government enforces the Stark and anti-kickback laws. I'm offering this testimony on behalf of Taxpayers Against Fraud Education Fund, a nonprofit organization that provides education and supports the federal and state false claims acts and laws intended to protect taxpayer funds. The president and CEO of Taxpayers Against Fraud, Bob Patton, is here with me today. I've submitted written comments for the record, and I won't repeat them here this afternoon. I want to address just three general arguments and respond to them that have been made about the need to reform Stark. This afternoon's hearing is to address ways in which the Stark self-referral law hinders the development of value-based coordinated health care and provide possible solutions to this concern. We believe really the threshold question for this subcommittee is to identify specifically what, if any, problem exists related to the development of value-based care that needs to be rectified and can't be addressed within the existing Stark framework. Stark is a critical tool for the government in checking conflicts of interest and in the delivery of federally funded health care and ensuring that patient needs, rather than financial interests, are the focus of medical decision-making. Proposals to eliminate or substantially curtail application of this important anti-fraud law to broad, undefined categories of arrangements should be approached with caution. I'll touch briefly on several arguments that have been advanced about the need to amend Stark, many of which predated the move towards value-based care. First, that the law blocks or restricts innovation. Second, that the law is too complicated. And third, that the penalties and complying costs are too high. With respect to innovation, which sounds like something we can all support, the case hasn't been made that the law as it exists and the ways of providing for regulations and advisory opinions stands in the way of innovation. To a degree, all ethics laws restrict the ability of persons or industries to innovate, but they do that because there's some important value that we place above unrestrained innovation. Here, that value is ensuring that financial interest doesn't skew healthcare decision-making that affects patients. And this is particularly a concern where the government subsidizes those healthcare decisions on a vast scale and cannot easily evaluate each transaction to determine if it's compliant with healthcare patient needs. If there are specific arrangements that do not present a risk of conflicts of interest, there are existing mechanisms to propose them and to have stakeholders opine on how those arrangements may or may not implicate conflicts of interest. Those mechanisms may not work as quickly or as efficiently as the regulated community may want, but taking the time to evaluate competing claims is necessary to help avoid unintended consequences. We've also heard the law is complicated, but it's important to remember that the basic idea of the Stark law is pretty simple. The regulations that expand on the exceptions to the law provide flexibility in a changing environment. As we've heard, laws can sometimes not keep up with developments in industry, but the regulations allow for flexibility to address those changing environments. The regulations allow providers to structure arrangements in ways that do not violate the broad prohibition on self-referrals. We've heard a lot this afternoon that people find it difficult to comply, but there are many circumstances where they can comply. There's no necessary indication that the law itself needs amendment. The regulatory process provides the flexibility to address changes in the healthcare field without undermining the basic premise of the statute, which has stood the test of time. The penalties for violating Stark are high, but there's a reason for that. Without high penalties, violating the law can be just the cost of doing business. The purpose of high penalties is to ensure that providers take this prohibition very seriously. What is at stake is taxpayer money that is spent on individual patients who are affected by those decisions. These are not minor issues. According to the GAO report that was issued this month, the federal government spent $700 billion in 2017 on healthcare. Requests for blanket exceptions to the fraud laws that prevent those funds from being expended inappropriately should be approached with extreme caution. I thank you, and I look forward to the opportunity to answer any questions.